Today we're going to talk about S-corporation reasonable compensation audits, payroll tax, and income tax overlap problems. S-corporations routinely attract payroll tax scrutiny. If you operate an S-corporation and you have a history of paying yourself very low amounts of W-2 wages, while at the same time taking large distributions of profits, you are in a high-risk audit category. The IRS in most states are well aware of the fact that distributions from an S-corporation generally avoid self-employment tax. Wages, by comparison, do not. And when they see a pattern of low salary coupled with high distributions, they do not treat this solely as an income tax audit issue. They also look at it as a potential payroll tax audit issue. So what's reasonable compensation? Well, the IRS position is straightforward. If a shareholder performs substantial services for their corporation, the corporation is required to pay a reasonable amount of W-2 compensation for those services. Whatever labels you use don't control. Calling payments distributions does not prevent reclassification. Courts have repeatedly allowed the IRS to recharacterize distributions as wages, especially when the salary paid was unreasonably low relative to the services the shareholder provided to the court. Once that happens, the federal and state payroll tax exposure begins. So how does the IRS build a case here? Well, the issue often surfaces in an employment tax audit, looking at Form 941, or as a broader S-corporation income tax exam, which will most likely morph into a personal tax exam of the affected shareholder. A discrepancy between W-2 wages and K-1 distributions causes a problem. Examiners come in and compare officer duties to hours worked, to corporate profitability, to comparable industry compensation amounts, historical salary patterns. If they conclude compensation was artificially suppressed, they're going to reclassify distributions as wages. And once wages are increased retroactively, employment tax, penalties, and interest accrue at a minimum. The payroll tax overlap problem here triggers federal and state assessments of employer share of FICA, employee share of FICA, feudal exposure where applicable, payroll deposit penalties, corrected W-2 and W-3 filings, amended Forms 941s. And the issues never stop at just federal tax. In California, for example, payroll compliance runs through the EDD, the Employee Development Department. If wages are increased for federal purposes, California wage reporting must align as the two agencies communicate. That means potential overlap with D9 and D9C filings, state withholding, state payroll penalties, and listen, quick retroactive payroll fixes without a coordinated strategy can make the problems exponentially worse here. So when does civil exposure become federal and state criminal tax risk? Admittedly, in most reasonable compensation audits, the dispute remains civil. But criminal tax exposure can arise when the facts show intentional conduct. The red flags here: zero or near zero wages for active owners, large personal distributions tracking lifestyle, inconsistent payroll filings, backdated W-2s, fabricated corporate minutes, false Forms 941, or failure to deposit employment taxes. If the IRS believes wages were intentionally suppressed to evade payroll tax, the case can escalate into a criminal payroll tax investigation. There's also risk of the trust fund recovery penalty here. There's another layer of exposure many owners are unaware of. If payroll taxes were not properly deposited, the IRS can assert the trust fund recovery penalty. That creates personal liability for responsible persons. They can be employees, owners, officers, doesn't matter. A reasonable compensation adjustment can retroactively increase trust fund amounts, which means the IRS may pursue individual liability for payroll components. This is where business exposure becomes personal exposure. So how do you defend a reasonable compensation audit? Well, it's not about drafting a memo after the audit begins, I can tell you that. It requires a fact-specific approach. You have to examine the roles and duties, the hours worked. You have to look at comparable market compensation studies. You have to look at business profitability. It can be helpful to do a capital return analysis. You got to put together contemporaneous documentation. The IRS is going to come in and use a facts and circumstances approach. It may be possible to demonstrate that the distributions represented a return of capital rather than disguised wages. Any attempt to make such an argument must be attempted without creating contradictory statements or making unnecessary admissions. So why does attorney-led strategy matter here? Well, once the reasonable compensation issue turns adversarial, you should not route communications through your original preparer. You need attorney-client privilege. You need controlled communications. You need coordinated accounting analysis that's done through counsel so it's protected. Because once willfulness is alleged, small statements can become very large problems. In egregious cases, this can quickly become an eggshell audit or a reverse eggshell risk scenario. Check those terms out on my website. And any civil or criminal tax defense must be structured accordingly. So in closing, if you operate an S corporation and you worry about your compensation structure, if you worry it may trigger IRS scrutiny, you need to treat this problem as a payroll tax case with potential income tax spillover issues. Whatever you do, don't treat it as a simple salary memo issue. At the tax law offices of David W. Klasing, our dual licensed tax attorneys and CPAs routinely coordinate civil and criminal tax defense strategies to prevent escalation. Call 1-800-681-1295 or visit Klasing-associates.com to request a confidential reduced rate initial consultation today. To date, no client we have ever represented in any type of an income tax or payroll tax audit has been criminally prosecuted for tax crimes.